You may be seated. Jefferson County Court Law number 2 is back in session. The court is in session. The cause number M331246. Case is filed in the state of Texas versus Tallis Clavell Jr. Let the record reflect that Mr. Clavell is present in court with his attorney, Attorney Jennifer DeLage. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Fred Vernon, and Attorney Cornelius Williams. Let the record also reflect that the jury is now present and seated in the courtroom. Ms. DeLage, the state arrested this case, and Ms. DeLage?
Yes, Your Honor. I'd like to start with the opening statement.
Yes, you may proceed.
Thank you. Good afternoon, everybody. Thank y'all for being here again this afternoon. This has gotten real fun. I want to start by saying, we are here for a death case. And the state has the burden of proving beyond any reasonable doubt that every single element of this crime has been proven, okay? And we've talked about the elements. The first element is you have to identify the defendant as the person who committed this crime. That means we need to identify him as the person who was in Market Basket, and we need to identify him as the person who signed those money orders. We've seen from the state's evidence. No one sat here so far in the state's witnesses and said that they could point out that the defendant was the person in that video. Additionally, we see the money orders and we looked at them. And there's definitely reasonable doubt that the money order signatures do not match the signature we know is the defendant, because that was signed to get him out of jail on the surety bond. So neither of those two elements, neither of those two scenarios have helped to prove the element of identifying my client as the person who committed this crime. And especially not beyond any reasonable doubt. The next thing they have to prove is that there was a taking, which I think there's some conflicting evidence about whether anyone took those money orders or whether Miss Parker misplaced those. We saw Miss Parker with her purse. Looked like there was a lot going on in there. We also saw that Miss Parker somehow ended up with one of the exhibits in her purse. So there's, to me, reasonable doubt that the taking ever took place, okay? But then they have to prove that the taking was unlawful. That would mean someone intentionally took that. So intent is that third element that they have to prove beyond any reasonable doubt. And there was no evidence that came on that showed that my client, the defendant, had any intent to take these money orders. Now, what we will show, and let me back up. We talked a little bit in Board Hour about the fact that it is on the state to put up all of the evidence. They have to prove all of this beyond a reasonable doubt. And that we, the defense, would not have as many witnesses. We wouldn't have as much evidence to put on, because all we're here to do is show you that the defendant is not the person who committed this possible crime. Okay? All right, so what we will show is that this happened in 2021. My client is arrested 4 years later and asked where he was on September, I can't remember the date, September 17th, whatever it is, of 2021. Was he at Bruce's Market? Do you remember where you were on September, whatever date of 2021? I don't. So, my client, we're going to show that he does not remember, but he does not believe that is him in that video. We're also going to show that he did not sign those money orders. That was not him. We're also gonna show that my client even if you were to find that that was my client in that store, there was no intent for him to have taken anything. But mostly we're gonna show you that my client was not the person who did this. He didn't do it. And we only have to show you that beyond any reasonable doubt. This is a very high standard because our liberty is a guarantee here. And we are guaranteed the right to a speedy trial 5.5 years later. And the right to have a defense to charges from the state. And in that right, the state is the one who bears the burden of proving every element of this beyond a reasonable doubt. And at this point, we're going to prove that you should find that my client was not guilty of committing this crime. Thank you.
Mr. Ledge, you'd like to call you first witness?
I would, Your Honor.
Okay.
May I call my client, Dallas Clavell?
Okay, Mr. Clavell, would you please come forward and raise your right hand? Yeah, Mr. Clavell, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Mr. Clavell, you may put your hand down. You can take the witness stand and adjust the microphone in the chair.
Good afternoon, Mr. Clavell. Will you state your full name for the record, although I believe it's Pat Body?
My name is Dallas Clavell Jr.
Thank you. Mr. Clavell, you live in Port Arthur, is that correct?
Yes,
There are at least 2 other men named Dallas Clavell who live in Port Arthur, is that correct?
yes,
You are related to those 2, but there may be more, is that correct?
yes,
All right. While we know you live in Port Arthur, there were many different addresses that the state showed you to be at, is that correct?
yes,
And they never showed direct evidence that you lived at the home where the energy bill was paid for, is that correct?
yes,
Four and a half years after this incident happened, you were made aware that you've been charged with this crime, is that correct?
yes,
All right. And at that time, you had to think back to where you were on September X date of 2021, right?
yes.
And when you thought back, did you remember exactly where you were on that date?
No, that's quite a while.
Right, okay. And you have seen the video that was produced in here, is that correct?
Yes,
And you can't be sure if that was you in the video, is that correct?
yes,
Okay. You definitely don't remember being there.
yes,
Okay. Now, playing devil's advocate for a moment, if you were there, you certainly wouldn't have had the intent to take someone else's money.
no,
You would say that that is not in your character
no,
and it's not something you would have done. So, although you don't remember if you were there, you're certain that you wouldn't have done that.
no,
Is that correct?
yes,
Okay. Now, so this incident happens in 2021, and then there's a period of 4.5 years where you're just living regular life.
yes,
Did part of that regular life include sometimes making trips into that market basket?
yes,
Did anyone ever approach you while you were in that market basket?
no,
Did anyone ever ask you if you were part of what the incident that had happened on that day?
no,
All right. All right, I'm gonna pull up some evidence real quick. 2 of the exhibits. One is exhibit 10, which is the surety bond, and that's the one that you signed when you were released from jail, is that correct?
Yes,
And then we're also gonna pull up exhibit 5 or 6, both of which we have objected to being entered in here, correct?
yes.
But we're gonna pull those up and let you take a look. All right, give me just a second.
Well, before you do that. She needs to put that on this here.
Okay. What do I need to do?
Just hold on. We have to get our coordinator, and she'll have to take that off the screen and put it on the computer.
Thank you.
I can do it.
You can? Okay. Put back up there. Sebastian did. Okay, he can tell you what wires to take disconnect. Hold on a minute. Yeah,
I did warn you, I'm not getting lost technologically.
thank you.
This is different of his.
Thanks a lot.
That's for you now. That's you now.
Yes, yeah.
Okay. We did it. Thank you. Good job. I'll take a little credit. All right. So you see those two exhibits, don't you, sir?
Yes,
Right. The exhibit you see on the left, which is the surety bond, exhibit number 10.
yes,
Do you recognize that to be your signature on the surety bond?
yes,
Now, the money order that is to the right of the screen has 3 different signatures. Do you recognize any of those signatures to be yours?
no,
Okay, and you can see the distinct differences in those 2 signatures. Correct?
yes,
All right, so. This has been a long time in the making, hasn't it? Sam?
yes.
And I've seen you holding a piece of paper the entire time. Can you tell me what that paper says?
It was a little flyer, with scriptures on it, and also, what, you, presented to me,
Right.
to read over.
So has this been a hard 4.5 years? Well, it wouldn't be. It would be from the time that you were made aware. So the last 1.5 years.
Yes,
And have you been adamant that you've been innocent throughout this whole time?
yes, that's correct.
Every conversation you've had with me, have you been adamant that you were innocent?
Yes,
And do you believe that this is just a mistake on your identity?
well, yes,
And you definitely do not remember being in Market Basket that day.
no, not that,
You do not recognize yourself in that video.
no,
And you did also see in the video that there was another gentleman that walked up to the money order booth right after the victim left. Is that correct?
yes, that's correct.
Did anyone ever question that man to your knowledge?
Objection calls for speculation.
Objection sustained.
No,
Are you aware?
Objection, Judge. Just, I got us, I'll ask move to strike.
Okay, that will be stricken from the record. Okay,
Are you aware of any other persons that were questioned related to this case?
no,
Did it seem like they just came to you immediately?
yes,
All right. But this was not you.
no,
You did not do this.
no,
You are not guilty.
no,
And you want the judge, the jury, and the prosecution to understand that you deserve a not guilty verdict.
Yes.
All right. Your Honor, I'll pass the witness.
Mr. Williams,
Judge, before you begin, may we approach?
hold on a minute. You may be seated. Jefferson County Court at Law number 2 is back in session. The court is in session Mr. Clavel, you could take what you said. The court is in session in cause number M331246, case of style of state of Texas. You can go. The case of style of state of Texas versus Dallas Clavel Jr. Let the record reflect that Mr. Clavel is present in court with his attorney, Ms. Jennifer DeLage. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Fred Vernon and Attorney Cornelius Williams. At this time, the jury is now present and seated in the courtroom, and Ms. DeLage, that past witness, and Mr. Williams, you may proceed.
Thank you, Your Honor. Good afternoon, Mr. Clavel.
Good afternoon to you too.
Mr. Clavel, you stated on direct examination that it's not in your character to take other people's things, correct?
Yes,
You remember you saying that? Now, this isn't the first time
Objection.
that you've been,
Just to preserve the record.
Okay. Yeah, that's overruled. You may proceed.
now, this isn't the first time that you've been accused of taking other people's things, correct?
yes,
And in fact, you were accused of taking a person's car without their consent, correct?
not to my understanding.
So you tell the members of the jury that you've never been accused of taking anything from anybody, correct?
Well,
Isn't it true, Mr. Covell, that roughly 30 years ago, because you just said you never took anything, never been accused of taking anything that belonged to anybody else. Isn't it true that back in 1997, you took an automobile not belonging to you?
no,
State's gonna have marked as State's Exhibit number 11.
Your Honor, I have an objection to the entire thing being admitted. We talked about one. So we need to redact part of that.
The state will certainly
One
do that,
page we
Judge.
talked about.
The state will certainly do that. We'll make a printed copy of just what was just addressed. And
That's
be up
it.
to
So
the,
that's my objection.
Okay.
and be up to the jury to determine the. Okay. We know there's 3 Dallas Clavels that lives in Port Arthur, or at one time did in fact live in Port Arthur, correct?
yes,
Isn't it true that your daddy name is Dallas Clavel?
yes,
He was born in 1947. Isn't it also true that there's a Dallas Dwayne Clavel?
oh, yes,
There's a Dallas Dwayne Clavel, and he was born in 1977, correct?
I don't know what his birthday is.
Okay, so you don't know your stepbrother's birthday.
We wasn't that close.
Understood, understood. Now, back on in September of 2021, now there's no other Dallas Clavels with the name of Dallas Clavel Jr. in Port Arthur, correct?
No,
No, only you, correct?
yes,
And back in September of 2021, an electric bill was paid, correct?
I don't know. I don't have, no,
Well, let me show you what's been marked and admitted as State's Exhibit number 8. Since there's only one Dallas Clavel Jr. in Port Arthur, correct?
right,
A State's Exhibit, is this refreshing your memory? State's Exhibit number 8, that Dallas Clavell Jr.
My name
Hey,
is
Bill.
Covell Jr., but I don't recall
You don't recall?
that date.
Do you recall ever having this bill for Dallas Clavell Jr., the only person in Port Arthur by the name of Dallas Clavell Jr.?
I'm Dallas Covell Jr., but I don't recall a memory
Okay,
of that date.
okay. What about this bill? The bill, you ever had an energy bill?
Yes.
Okay, and you had an energy bill addressed to you. You get your energy bill in the mail, correct?
Yes.
And the energy bill, which is shown on State's Exhibit number 8, is to Dallas Clavell Jr. in Port Arthur. Correct?
Yes.
But you don't remember ever paying this bill,
Not on whatever date you're talking about. No.
okay? Mr. Clavell, write your name
Objection,
7 times within 46 seconds.
objection,
State versus Olson, Yarn is non-testimonial. He can clearly do that. 7 times within
Objection
42
overruled.
seconds. Write your name, your signature 7 times starting now.
objection. This is ridiculous, Judge.
Objection is overruled. It's a sample equal.
Write your name 7 times within 42 seconds. Start, please, Mr. Vernon. Time. Stop. Within. You were given 42 seconds. You're supposed to write your name down 7 times. Why didn't you sign your name 7 times, Mr. Clavell?
You didn't give me time.
We gave you 42 seconds. How long does it take you? Let's see. We have 2.5 signatures.
Taking a test.
Okay.
You have
Objection
2.
overruled.
Thank you. You have 2.5 signatures written. Correct? 2.5 signatures,
Yes.
correct?
Correct.
Let me mark this as State's Exhibit, have it marked as State's Exhibit number 11.
Objection to the exhibit being admitted.
It's being marked.
This is a new discovery. Not previously notified or presented to the defense.
All well and fine, but it just did in front before the jury's
Your Honor, this is
administration in
not-
front of the jury based upon State versus Olson. And
Okay.
its progeny it's not been overturned.
Okay, you have state versus Olson.
Yeah, do you have?
That's correct, Judge.
I'm gonna ask that the, jury exit courtroom at this time.
Otherwise.
Okay. At this time, Mr. uh, Williams, you may proceed.
Thank you. On direct examination, when you're able counsel for defense, put your surety bond, remember seeing that you put up on the screen? Your surety bond
Yeah.
signature, and she placed up one of the money orders, correct?
Yeah.
And you looked at it and you said it was not your signature,
Yeah.
correct? Write your signature 7 times on the lines which you provided.
Your Honor, I object to
Yeah.
writing it 7 times. I request that my client only writes it 1 time, as is supported by current case law.
Respectfully, we just had this discussion, Judge. There is no current case law that says an exemplar is only 1 signature. There is no case law, Judge.
There is no case law that shows it to be any more than 1 signature. The case law only supports 1 signature.
Given able counsel's examination of the marshal within the case, when she went on about do you see a line, do you see a loop here? Are there lines, are there loops? They do not look similar, correct? She did the same thing on direct examination. What the state is doing now, Your Honor, is providing meaningful cross-examination so that this jury is not being deceived by able counsel for defense.
Your Honor, I believe it's a violation of the Fifth Amendment right to make a sign more than 1 time.
Okay. Objection overruled.
Seven times, sir. You signed it only 5 times now. Time.
Objection, Your Honor. We just discussed that no time limit was going to be allowed.
There was,
Rule-
Your Honor, there was no time limit placed.
Your Honor,
We
that needs to be stricken from the record.
Okay. This will be stricken from the record, a comment that has been made by the state.
How long did it take you to complete 7 signatures?
I wasn't time master.
Would 1 minute 14 seconds sounds about right?
Objection, Your Honor. Are we going to continue on this line of questioning you just sustained?
Objection sustained.
With that, Judge, the state's admitting, seem to, admitted evidence, state's exhibit number, it'll be state's exhibit number 12.
Okay.
I object based on my original objections, and I think you know what those are, but I have to object to preserve the record. Thank you.
Objection overruled. Okay.
I submit to you all that comparing states exhibit numbers 10, which is the surety bond, and what was presented to you today in court as states exhibit number 12, where both signatures appear, you will be able to make a determination. Because he testified, you heard him on direct examination, that he signed the surety bond. That he signed it. But when he signed today, we see Junior. There's no Junior on this, and I submit to you, and I submit. Here's the question. You changed, or you wrote a different signature than you did on the surety bond, correct?
No,
Okay, so where's Dallas Clavell Jr. on the surety bond, which is states exhibit number 10? Where is Junior?
only thing that's missing is Junior, but.
Yeah, the only thing missing is Junior, correct?
Yeah.
So it is different from the surety bond from 2025, correct? Than from today. Yes or no, sir?
Yes,
If I lived in Port Arthur, you normally go down to the Bruce's. You're familiar, as you stay on direct examination, that you're familiar with the Bruce's market basket, correct?
yes,
And you go down there and you buy groceries, correct?
no,
Or you don't buy groceries there?
no,
You only go there to transact business, correct?
that's correct.
You only go there to pay electric bills, correct? And purchase them. You go there to pay electric bills
Elected bills,
and other bills.
other bills and payroll sometimes.
And payroll, you go there and you cash your check for payroll and stuff too, correct? And in fact, in September of 2021, during like that COVID time, you went down to Bruce's Market Basket in the Groves, didn't you?
Not to my recollection, I don't know the date I went, but
I'm gonna play for you what has been marked in this, admitted as states exhibit number 1. We're just gonna watch it together. And I'll ask you a few questions. Can you turn around? Can you see the timestamp that's on states exhibit number 1 behind you? Can you see? 9/7/21, 14:56. Can you see that, sir?
yes, I think,
Judge, may I approach?
Yes,
I'm sorry. May I see the one? Feel free, you can stand up, because we will be looking at this number, okay? Can you see this number?
yeah, I think,
You,
yeah.
no,
9/07/21,
correct. And the time,
14/50.
14:56. You see 14:56?
I don't know if it's 6 or 0, but
It's admitted the jurors will be able to make that determination. Please hold this. Now, you just testified that you, when you go to Bruce's Market Basket, you don't do grocery shopping. You go there and you transact business, correct?
yes,
Okay. Isn't it true that that is you in the orange shirt and blue jean pants?
I don't think so.
You don't think so? Let me ask you this, why don't you think so? Do you own an orange shirt
Oh, several shirts,
and you own several pairs of blue jeans?
yes,
Okay.
Black jeans too.
Tennis shoes too,
Right.
absolutely. Now, do you recognize at all that person in the orange?
No,
Don't recognize him at all, right? So it is not Dallas Clavell, who was born in 1947, is it? Because you'd recognize your dad, right?
yeah, I probably would recognize my dad.
You probably would recognize your dad? You don't know if you would recognize your dad?
In flesh, I mean, depending on the circumstance.
Okay.
But that's not my dad.
No, it's not your dad, correct?
Correct?
And it is not Dallas Dwayne Clavell, is it?
No,
For the record, you said no, correct?
not to my record.
Okay. We're not asking about your recollection. We're asking about, do you recognize that person who's in orange? You already said that it's not your daddy by the name of Dallas Clavell. You also said that it is not correct, that it's not your brother, Dallas Dwayne Clavell, correct?
Correct.
Okay, so that's 2 out of the 3 Dallas Clavells in Port Arthur is gone. So that only leaves you, sir, correct?
Junior.
Dallas Clavell Jr.,
Okay.
correct?
Yeah.
If it's not your dad, if it's not your brother, there's only 3 of you all. That is you, correct? Okay. Now you walked over Dallas Clavell Jr., correct? You walked over to the booth to where you pay the bills, correct? That's the booth to where you pay the bills at Bruce's Market Basket over there in the Grove, correct?
Yeah, I guess. You could pay it at either one, really.
Okay. And you did see the lady that just leave from there who's walking with the mask on, correct? You see her?
Who is that?
Do you see her? A lady
Yeah, I
just
see her.
walked away. You were sitting right there next to counsel for defense, with your counsel, when Miss Gloria Parker took the stage. You heard her, correct?
I heard.
Okay. Miss Gloria Parker testified and said she had paid her energy bill. Remember that? You were sitting right there.
Yes.
It was
Yes.
doing this week. You remember her saying that,
Yes.
correct? And you remember that she said, I recognize the guy from behind me because I know his daddy and I know his aunt, correct?
I think she said something like that.
Yes, sir. You've heard testimony from Mrs. Meir, but also the detective. Remember that testimony? And do you remember their testimony, sir? Yes or no?
Not
Not really?
really.
But you do remember you do remember that State's Exhibit number 8, which is an energy bill with the name of Dallas Clavell Jr., was paid after Mrs. Gloria Parker's bill. Correct?
Yeah, this is my name.
Dallas Clavell Jr., correct? So we know it wasn't your daddy behind Mrs. Parker. We know it wasn't your brother behind Mrs. Parker, right? So by process of elimination, it was you whose name appears on that electric bill who was behind her. Can we agree on that?
Not to my recollection, that's
Okay,
5 years ago.
yes, sir. Okay. Now, through the court's scope of the investigation of the detective and through the records of Market Basket, can you explain to the members of the jury how money orders, which was purchased by Mrs. Gloria Parker on September 7th of 2021 ended up in the hands of Dallas Claville, who was standing behind her on that day?
Can't explain that because there was a whole lot going on, probably.
Okay.
Cashiers could have.
Okay, there's no questions. Okay, before you. Let us, then we'll conclude this. I want you to watch. You saw the lady who was right before you, that's it at the screen, correct?
Yes,
You still at the counter, correct? Well, let's do it like this. It's not your daddy standing at the counter, correct? And it's not your brother standing at the counter in the orange, correct?
correct.
Isn't it true that that is you at the counter?
Could be what date, I mean. I don't remember, it's
Okay.
been 5 years ago,
Understood?
it's a long time.
Yes, sir. But an 81-year-old woman remembered. You see that 81-year-old, I'm sorry, at the time, 78, 79, I'm sorry, 77, 78 years old at the time. See the woman in the white shirt that you just looked over to? You see her? Do you see her for the record, sir? Yes or no?
I see her at the counter.
Okay. And you just walked by her, correct? You just passed her while she's at the counter.
I don't remember.
Okay. When you left from paying your bill, State's Exhibit number 8, you did not stop and say, ma'am, you left something here. You went out the store, correct? Or you left that area, right?
I don't remember. It's 5 years ago.
State will tender the witness. Wait, Judge, I'm sorry, one moment. The state will pass the witness. Judge.
Okay. Mr. Lage,
Thank you, Your Honor. Okay, first, let's talk about the video for a minute. No, don't need it. Thank you. Oh, yeah, that's me. Let's talk about the video. So the state is saying to you, you know for sure that's not your dad, you know for sure.
Judge, I must start objecting now to the leading of the question, Judge. It's the form of the question.
yeah, you can't lead on that, right?
Is it possible that you were, what, was the camera blurry?
Objection again, leading, Judge. It specifically calls for a yes or no answer.
Objection sustained.
Can you tell me if you could really tell if that was your dad or your father?
Once again, leading, Your Honor.
Objection
It calls for a
overruled.
yes or no answer.
No, it doesn't.
Objection overruled. Like you may answer.
Can you tell me in that video for sure that that wasn't your brother or father? Can you tell me why that might not be true? Why you might not be able to
Your
tell
Honor,
if that was them?
compound multiple question, and it's leading, Judge.
Objection sustained.
Can you please tell me if you can tell if that is your father or your dad and why?
He was a bigger guy.
All right. So with there being a blurry video, could you tell me for sure that your father or your brother couldn't have been that person?
Objections, assuming facts not in evidence as well as leading.
Objection
Assuming the fact
sustained.
that the video,
Objection sustained.
Let's go somewhere else. Tell me about the charge that the state brought up, that occurred back 30 years ago. Do you know anything about that charge?
30 years. Yeah. Not to my recollection.
If there was that charge, can you tell me, if you were ever convicted of a charge like that?
No,
if there was, I'm objecting to the form of the question, Judge. You just testified you don't recall, and now it's called speculative.
Objection sustained.
Can you tell me about that charge that was brought to your attention? And whether you've ever been convicted of
No.
any charge
no,
like that?
never been convicted, anything.
Can you tell me about your prior record? Is there anything that is on there you can tell me about?
WRK, work, day and night,
Right.
honest living.
Objection not responsive, Judge.
Objection sustained.
How did you feel about writing your name 7 times?
Objection as to relevant, how you felt about writing his name 7 times.
Relevance that's just occurred in this courtroom.
It is not relevant.
Okay, objection, sustained.
I felt very.
No, that means you can't answer it. Can you tell me on your own words if you remember anything about what happened 3.5 years ago?
No, not really, not verbatim, no.
Okay. Can you tell me, how many times you've ever stolen from someone?
No. No,
And can you tell me, in this case, whether you were a part of the allegations that have been made?
could you repeat that?
Are you guilty of these crimes?
Objection,
No.
now she's invading the province of the jury. That's for the trial fact to make a
He
determination.
can answer the question as to his guilt or innocence. It's just like pleading.
No,
Judge.
he can say, I didn't do it, and it's up to them to believe, not that I am innocent of the matter which I'm charged with. All he can say is he didn't do it, otherwise
He
he's
just said
invading
that.
the province.
He just said that.
No, he did not say that.
Okay, just rephrase your question.
Can you tell me if you did this crime?
No,
I'm gonna pass the witness.
Mr. Williams,
Nothing further, you.
okay, you have anything else?
Nothing but that.
Okay, Mr. Clavel, you may take your
thank you.
seat. And Ms. DeLage, do you have any other witnesses?
I have no further witnesses, Judge, and ready for closing.
You rest.
Arrest.
State, do you have any rebuttal?
No, sir, you don't, not for your plan.
Okay,
Your Honor, at this time, I'd like to make my motion for a directed verdict.
okay. Then, denied. Okay, now, and ladies and gentlemen, I'm gonna ask that you would step outside. We have to have what is called a charge conference. And then, once we finish with the charge conference, what will happen, the court will, bring you in, read the charge, and then the state and the defense will do closing arguments. Okay? Okay, the court be in
Oh, wow.
Okay, you may be seated. Jefferson County Court at law number 2 is back in session. The court is in session and calls number M 331-246, case of style of the state of Texas versus Dallas Clavell Jr. Let the record reflect that Mr. Clavell is present with his attorney, Attorney Jennifer DeLage. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Fred Vernon, and Attorney Cornelius Williams. The jury is now present and seated in the courtroom. Ladies and gentlemen of the jury, the charge, we have to have our charge conference. And so we're gonna ask that you come back tomorrow morning at 9 a.m. Okay? And basically, when you come back at 9 a.m., then we'll have reading of the charge, closing arguments, and then you'll go to deliberate. And I'll just to let you know now, while you're deliberating, we will be having court going on here inside the courtroom. So if you hear some stuff, that's us in the courtroom having going through our announcement docket on tomorrow. Okay, so that's what's going to happen tomorrow. All right, so at this time, we're going to ask everyone, please stand as the jury exits the courtroom. Okay, and y'all have a blessed day. You're welcome. The court will be in recess tomorrow. Let's see.